Mishcon Academy digital sessions.
Very big warm welcome to this Mishcon Academy digital session on trust stress testing. I'm Peter Steen. I head up the private wealth disputes team at Mishcon. The stress testing of trust is a crucially important part of a trustee's job. A surprisingly large number of trust structures that we come across are, to be frank, are out of date and not fit for purpose. And frankly, even more recent trusts can quickly become outdated. This is often due to changes outside anyone's control. Such changes are coming thick and fast at the moment and can take many different forms. Who is on our panel this morning? So we've got a mix of contentious and non-contentious practitioners across the private client spectrum. In no particular order, Emilia Piskorz is managing associate in our private wealth disputes team in London. Her focus is on cross-border and complex trust litigation. Simon Michaels, partner in our Singapore office, who has a huge amount of experience in advising high net worth families, family offices and trust companies on structuring and tax issues. And Charlie Sosna, partner in our tax and wealth planning team in London, who has enormous experience advising on international tax and asset protection structuring and lifetime planning for high net worth families as well. So to kick off, I'm going to ask a very generic question. I'm going to put it to you, Emilia, in the first instance. If you're a trustee and you're taking on an existing structure, what are the sorts of things to be thinking about if the trust has been running for a while?
I think when you're taking over a structure, one of the first stresses, as it were, is working out quite quickly what the key details are about your structure, which isn't always that straightforward. And that's particularly the case when you're taking over a structure that hasn't been that well run previously. And I tend to focus on kind of two areas quite quickly, and that's beneficiaries and the assets of the trusts. A trustee needs to quite quickly work out who their beneficiaries are, what interests those beneficiaries have, and what knowledge those beneficiaries have, if any, of their interest in the trust. The next thing that I would tend to look at is the interest of those beneficiaries, which hopefully is a little bit more straightforward because it should be set out in the trust deed. And then the final issue around beneficiaries is, do the beneficiaries of the trust know of their interests? We often see with structures not that well run that only one or two beneficiaries know of their interest, or much rarer, but we have seen it, no beneficiaries know their interests. So the next thing I look at are the assets held within the trust. If the structure's been well run, you'd hope to see up-to-date and historic accounts, financial statements, all the information about relevant bank accounts, a structure chart setting out information about the underlying holding companies, tax filings, information about investment portfolios, and information about all the other assets in the trust, land registry documents, contracts, etc.
And presumably it's very important to know what your assets are, because they could be located in multiple jurisdictions. And just moving on to you, Charlie, if there are presumably important tax considerations to bear in mind, depending on where your assets are located.
That's exactly right. And I think, we talk about sort of stress testing the trust. When you take over an existing structure, or even actually if you're starting a new one, that can be quite a stressful scenario for all the parties involved, because the trustees are wanting to show that, they're commercial, they're not asking too many difficult questions, but yet you've got to make sure that you are asking the right questions to get your groundwork right at the start. Or if you're taking over an existing structure, that you know what skeletons are in the closet that you want to be taking over this structure. So I think from a tax perspective, you want to have looked at where your assets in the structure are and thought about, do you have any local tax liabilities in all the relevant jurisdictions on those? Again, where are your beneficiaries? Sometimes, we live in an ever increasingly sort of, apart from the last year of lockdown, of people traveling and moving their residence frequently, and you've got to try and keep on top of that. The other thing is looking at what type of assets you're holding, not just from a tax perspective of what is your obligation to diversify as a trustee, or what is it going to be when you're taking on a structure, and is the asset class representative of that?
Yeah, and of course, trustees aren't the only power holders in the structure often, because you'll often have a protector as well. And it's critically important for both the trustees and the protector to understand what the scope of the protector's role is, and what the protector's powers are. Something that we encounter quite a lot is mission creep in terms of the protector's role. But because of the relationship between the protector and the family, often the protector becomes a kind of quasi-family advisor, hence the mission creep.
I think they are an incredibly useful tool frequently in getting settlors over the line, actually, of setting up structures and giving them some degree of comfort in having someone sort of to keep a watchful eye over the trustees. But that mission creep he talks about is so crucial, that you don't end up with a protector that's effectively acting as a trustee. And I think that that's sort of one of the other things that we see, and I know, Simon, you were going to talk about this, about sort of the governing law of the trusts, and how relevant that is nowadays.
It's important to make the distinction that governing law and residency of the trustees are two very different things. And it's quite possible to have a trust that's governed by the one jurisdiction where trustees are resident in an alternative jurisdiction, which will then impact tax liability. But the choice of law is important. The governing law sort of does what it says on the tin. It provides the framework of rules in which the trust is able to function. And one of the other very important dynamics when choosing which jurisdiction is going to govern the trust is also which courts are then going to be involved if there is going to be a dispute, or if applications are going to need to be made.
Moving back to you, Emilia, quickly, what other documents? I mean, I know there are issues in relation to chains of indemnities that can crop up when taking over a trust.
When trustees take over a trust, hopefully they've got good legal advice, and their deed of retirement and appointment is well drafted. But where you've got more than one predecessor, it's really important to look back at previous deeds of appointment and retirement, because, as you say, if there's an issue with any of those previous deeds, for example, they haven't been properly executed, or someone has purported to exercise a power to remove and appoint a trustee, for example, a protector. We touched on protector's powers earlier, and actually that protector doesn't have the power in the trust deed, then actually you might have a position where you think you're taking over the structure from someone who's not the current trustee.
What about settlors? Often we will see a very prescriptive letter of wishes from settlors that's been put in place. It's often a highly dominant settlor might be kind of lurking around in the background. Charlie, what are the sorts of tax issues that can crop up where you have a very dominant settlor in the picture? When
we talk about the stresses on a trust, one of the big stresses, I think, for many trustees can be an incredibly dominant settlor that can't quite come to grips with the fact that they're not his assets or her assets anymore. But one of the issues that we can see that needs handling very carefully is an overly dominant settlor that is basically telling the trustees what to do and treating the assets as their own. Because if you've got that and there is a clear sort of correspondence chain or nature in which the assets have been held with, then depending on what jurisdiction they're based in, you're going to have real issues. From a tax perspective, if it's a UK person, they're just going to be treated probably as the trustee and bring the trustee into being UK resident is one option. It could end up with the trustee just an argument that the trust doesn't even exist, that it's a sham, and actually, it's not there.
Emilia, what are the more, other than the tax implications of having a dominant settlor, what are the more kind of practical day-to-day implications?
There are all kind of two major, I think, implications that spring to mind for me. One is that if, for example, a settlor has extensive reserve powers and then can't be communicated with or loses capacity, you can end up in a situation where the trust just can't function anymore.
There are Asian families that have particular nuances to them in terms of the way they operate. And I was also aware that Singapore has some reserve power legislation as well. What's the position in Singapore?
I think there are certain cultural nuances here. Asian society is generally sort of patriarchal. There are sort of old conservative values at play. And I think one of the things that it's important to remember from a control perspective is that very often the wealth that's being created in this region has been created as a consequence of retaining a lot of control. That the wealth has been generated during times of, a lot of political instability very often. And so it then becomes an incredibly alien concept to them when what you're doing is transferring control and legal title away from the assets that you own, particularly in the context of those settlors that come from civil law jurisdictions, where the whole sort of concept of a trust and beneficial ownership and legal title and the distinctions there are entirely foreign and alien to them.
What about things that trustees can do in relation to potential external attacks on the trust? I mean, there's obviously a lot of case law on this.
Obviously, third-party attacks on a trust are a real source of stress. And one major area we're seeing is attacks on validity, and that's being used by creditors or someone looking to inherit from a settlor who's actually put most of their assets into a structure. Really common arguments we're seeing at the moment, or kind of trends, are around allegations that trusts are a sham, or that the settlors reserved such extensive powers that they're not deemed to have disposed of the assets properly into the trust.
Just moving back to you, Simon, very briefly, I know one issue I think that crops up frequently for you is the issue of trusts holding assets in civil law jurisdictions, which may not necessarily recognise how trusts operate. Families with wealth in Indonesia, for instance. How does that play out?
It adds another sort of level of complexity and potentially confusion, because where you're dealing with jurisdictions which don't recognise within their legislation what we understand a trust is, which is effectively a relationship, then you're in an ambiguous situation where either the trust is going to be categorised as something else, whether it's going to be regarded as entirely transparent and the assets are going to be considered still the assets of the settlor, or whether it's going to be treated as some other sort of entity, like a contract or a company. And this then often leads into a whole bunch of other issues that can be relating into the sort of the asset protection dynamics, which may have been a purpose of the structure, or how the trust itself will be taxed within those jurisdictions.
What about spouses and attacks by potential spouses? And particularly what I've got in mind is the concept of nuptialization. I don't know if that's something you come across.
Yeah, London's frequently talked about as being the divorce capital of the world, and Mishcon, we have a big family team. So it comes up a lot of seeing attacks on the trusts. And the role of the trustees there is a really difficult one. I think you'll go through various different sort of demands and requests as a trustee in those kind of scenarios. And I think you need to be careful when we talk about nuptialized settlements. It's really about sort of the availability of the assets in the trust on a divorce to be seen as part of the family's wealth that's up for divvying up.
We've had some interesting questions come in. What is HMRC particularly aggressively looking at the moment?
They're being quite vocal that they are doing a more detailed review on domicile. So Singapore and Hong Kong are examples, actually. People will go there from the UK, and then after a few years, they'll be locally advised they'll settle a trust, not realising that actually they're still UK domicile and there's huge repercussions.
This one's come in relation to a retiring trustee's reluctance to hand over records, and particularly historical financial records. What is the position from a legal perspective?
I suppose that firstly, existing trustees can hold on to documents if as part of the LDN. But I think once a DORA has been entered into and there are kind of no outstanding fees, there's not really any justification for still holding on to documents or assets of the trust anymore.
We've now come to the end because we've unfortunately run out of time. I think the key point is that the contentious issues that we see come across our desks are often predictable and avoidable. And we often look back and think, well, if things had been done differently in the past, they wouldn't be on our desks at all. So thank you very much all for your time. Thank you from everyone on the panel. And we will leave you to get on with the rest of your day. Thank you.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.